Okay, let's bring him in here.
All right, so let me see if I can get that done.
Let's bring him in here.
Okay, thank you. We'll just bring him in here.
Can you let him know I got a hearing problem? Okay. He said, he is hard of hearing.
Well, that makes two of us. I've got a hearing aid coming on the beginning of June, so I'll just try to talk loudly. Is it okay if I...
Yeah, I can read lips.
Okay, good. Mr. Copeland, good morning.
Good morning.
All right, I just wanted to bring you over and let you talk with Miss Bumpus and see if there's anything you need to ask of your counsel, of Miss Hilton, of the state, or the court before we bring you out this morning. Because it is, we would like to hear your testimony. Okay,
well, I
and
want to
that's
speak with you
kind of where we
personally
are at this
that
point in
I have never
time.
been truthful a day in my life until I
So, is
just
there
made
anything
this
you would like
statement
to
right
ask
now.
at this point
I
in
don't
time?
comprehend none of this stuff that's going on.
Okay, well, only thing you can give is truthful testimony. I mean, whatever you know is whatever you know. I mean, that's it.
And what we'll say, and Mr. Copeland and I, we have talked about this. I'm not sure what your concerns are, what concerns that you've expressed to Mr. Melnick last week. But if any of your concerns deal with being locked up for anything, you can't. Like, there's nothing that can happen. The feds, well, it is true. No, I said that's not his concern. If his concern is his safety, we need to know that. Like, that's not expressed. So we don't know what the concern is so that we can try to resolve the concern. That is what I'm saying. Mr. Copeland and I have had conversations before. I understand some of his concerns as potential criminal liability, hence why we gave you immunity. The federal statute of limitations, done. The statute of limitations, done. So there is nothing, like I researched it this weekend again. Both of those statutes of limitations for what you and I talked about, which is in 2015 or before, done. You cannot be prosecuted for anything you testify federally or statewide. Immune, period. So if that is a concern, there is none, because you cannot be prosecuted. The federal statute of limitations is 5 years. So anything in 2015, 5 years would have been 2020. Anything statewide is 4 years. That would have been 2019. Finished. Next concern, what may happen in the street? You know what we have talked about, what we can do as far as living and all that. We have had those conversations. So I'm trying to express to you that we do not want you locked up. I don't know how many times I've got to tell you what I've got to say to you. We do not want you sitting in the cab or whatever they've got you because of this. I know you wanted to talk to me on Friday before you walked into court. We weren't able to talk. If you still want to talk with or without Miss Bumpus, I'm here, little Woody. But we do not want you in custody. We will not. This order, I don't know if you kept your copy of the order, but this order says you are immune from prosecution, little Woody. Any of it. Literally, Judge, you might want to close your ears. Judge, you might want to close your ears. If you confess to a murder on the stand and we don't have any other independent evidence outside of what you say on the stand, you are immune from prosecution from what you say in court. So again, I don't know what was communicated to you on Friday. I have no idea. But what the state has assured you, which I have assured you in our private conversations with Mr. Long, as I'm saying in front of Miss Bumpus, as I told you, that is what the order says.
And that's on direct or cross-examination.
And that is on direct or cross-examination.
So if you're worried about what the defendants may ask you because they may know your business, but if they ask you about things that you might think you might have, you can't be prosecuted for any of those things.
I got family members watching this trial, and I don't want my nephew and them to hear the things that I may be involved in and think it's okay. But I think that's a separate conversation you can have with them as an honest individual. Like, look, nephews, I done lived the life that I don't want you to live. Don't go through what I've been through. But that's something you can have outside of being in jail, because that's a better conversation you can have with your nephews in person. But they shouldn't have to come to the DeKalb County Jail because you're being held in contempt. You can have that conversation with your nephews tomorrow in person. You can have that conversation with them. You can have that conversation with anybody. You know what's coming up this weekend. Why are we in jail? What are we doing? But y'all did this intentionally. No, we did not. You and I had this conversation, Mr. Copeland, on Friday morning. You knew my child's birthday was next week. But what did I tell you? When we met with each other, I said to you, you asked me, what is the one thing that's going to get me in jail? Didn't you ask me that? And what was my response? If you plead the fifth. And that is exactly what you did on the stand. But what did I tell you before I got to that point? I told you the whole time, Tuesday, Wednesday, Thursday. But I told you we were giving you immunity. That I was pleading the fifth. No, you did not. I told you every day I was pleading the fifth. No, you did not. And we told you. I told you my concern. And we said we could give you immunity. You said your concern is what they know about you. And when you said that, I said, well, you know stuff about them. And then I said, whatever your concerns are, we can give you immunity. So I didn't tell you I lied on them to get myself out of the situation. And you said you were a liar. That's what you said. You said you were a liar. Was this recorded? No. And did he ever say that to Melnick was his attorney? No. This week, when we first met you in the car on Friday, we asked you, is Mr. Melnick your attorney? You said he's not my attorney. I haven't talked with him. No, I never said he's not my attorney. I said I haven't talked to him. You said he's not your attorney. You haven't talked to him. Then we continued to have a conversation. At no point did you ever say to us, hey, I want Mr. Melnick here. Hey, put Mr. Melnick on the phone. You didn't make me feel like I needed him. But if you needed him, we would have said, if you would have needed Mr. Melnick, we would have said to you, okay, just call him. So, I mean, that is our position. We don't want you in jail. We just want you to be able to purge yourself by testifying. Whatever your truth is what your truth is. But you have to just get an answer to the questions. We believe that whatever your truth is what your truth is. We know what you said before. I don't know what you're going to say on the stand. But what we know is pleading the fifth is going to keep you in custody. That's what I know. Now, how you answer your questions is how you answer your questions. I know what you said before, and I know what you said later. I mean, I know what you said before, and I don't know what you're going to say on the stand because you and I never went into full details about any of it. But what I don't want is you to be sitting here in custody. You did it. You told me before you went to the judge with whatever the thing called you went to him with, you told me that I can't, when I'm asked a question, I can say I don't recall or I don't know. You told me that if I plead the fifth, I mean something. Why would I plead the fifth to something I ain't do? And I said, you don't know what I did and what I ain't do. And then you was like something. And then y'all asked for this immunity. And I was like, it was something. And then Friday came, and then y'all go and tell me, oh, we went to the judge with this, so you got to testify. If you don't testify, the judge gonna lock you up. Right. But that was based upon you. But I told y'all that. No, you didn't. You said, why would I plead the fifth to something I ain't do? And I said, you don't know what happened. And I said, I don't know what happened. Only you know, and them know, I said. But you never said I'm pleading the fifth. You said, what if I do this? What if I do this? What if I do this? I told you, I said, I'm going to plead you said, why would you plead the fifth to something that you know you ain't do? So if you didn't have immunity prior to, is that what you're saying? That you feel like he didn't have immunity prior to? Immunity came Friday, right when I went to jail. The immunity only came after Mr. Melnick. Hold on. The immunity came after Mr. Melnick sent us an email saying my client is pleading the fifth. That was on Thursday evening at 6 p.m. Okay. So after that was an empathic? He was pleading the fifth. We came and we got this sign. And then Friday morning came. Okay. Between Friday evening, Mr. Melnick reached out to us and he represents him. He's pleading the fifth. Okay. And when was the last time you talked to him before Mr. Melnick got involved? We talked to him early that day on Thursday. Okay. Then how did he called me? Okay. I was just trying to get a timeline. Sure. Right. So we have been talking since last Friday. So I met with Mr. Copeland last Friday, I think out in the neighborhood. Then he came on Tuesday for court. We talked briefly on Tuesday. And then on Wednesday he came. Thursday. No, I think he only came 2 days. So it had to be Wednesday and Thursday he came. It wasn't Tuesday. It was Wednesday and Thursday he came. And then on Thursday, once we left, is when Mr. Melnick reached out to us and said, my client is pleading the fifth. And at that point is when we went to the next morning and got the immunity motion. And then we spoke on Friday morning. I handed Mr. Copeland this agreement and let him know that he has immunity and that anything he says we cannot use. Then Mr. Melnick came and then we had court. So you're pretty much saying you didn't ask for this. I didn't, but we gave it. He doesn't have to ask for it. I know. I mean, I'm just saying. Right. He doesn't have to ask for it, but to alleviate whatever his concerns were, we gave him immunity. He didn't have to ask for it. So if we wouldn't have had this, I'm just saying this is so he can understand it. I'm walking him through. So would he still have to testify or would he have been able to plead the fifth? That's what he's saying. If he did not have immunity, yes, he could plead the fifth. That's what
Morning. All right.
That's what he's trying to say. He's trying to say he didn't have to ask for this.
Any detective from the Atlanta Police Department.
No, ma'am.
Did you drive any vehicle at all on September 11th of 2013?
I can't recall, ma'am.
Do you recall ever being inside a Taurus with Detective David Quinn that he described as a raggedy-ass Taurus?
Objection, hearsay. I sustain objection.
Do you recall being in a raggedy-ass Taurus with Detective David Quinn around September 16th, 2013?
I don't recall, ma'am.
Little Woody said, that's what he's trying to say. He's trying to say he didn't have to ask for this. But he doesn't have to ask for it. Now that we've given it to him, because that's on us. So now that we've given it to him, it's in order. He can still choose if this is the road he wants to take. Then he'll just stay in custody until the trial is over. Oh my God. And then we say the trial is over. Every last defendant has been tried. Not just these 6, the other ones too. I done did longer time. All right, Mr. Copeland, I'm telling you that you are literally immune from prosecution from anything else you may say. That's that. So the choice is always up to you. But we wanted to put on the record, the state does not want you in custody. What the state would like you to do is purge yourself from, what purge yourself mean? Meaning that you are no longer in custody. And the way that you purge yourself is to testify. That is kind of how it happens. And that is what the state wants you to do. We want you in custody. We don't want you in custody. We can't say that any other different way, but we don't want you in custody. The only thing that's holding you is you refusing to testify.
So do you have any questions? Any other questions? Basically, if you invoke the 5th...
I don't know what's going on. I don't trust nobody. I don't trust her word, but I don't know what's going on, Your Honor. This is your insurance. I don't know if you want to break that down to him. Well, he doesn't want that.
But he's been given it. See, that's the challenge, Mr. Copeland. Is that if they didn't give you the immunity, you could invoke your 5th Amendment privilege, but what the state has decided is that they said your testimony is worth more to them at this point in time, and they really want to know what you have to say. So they've made from the state's perspective, they've made a decision to give you immunity, so you no longer can invoke your 5th Amendment privilege. You have to testify, okay? So that's the difference in this particular scenario, is that they have taken away, well, you can still invoke your 5th Amendment privilege. You can still do that, but the consequence of invoking it, you will just remain in custody. So if you testify, you get out of custody and you stay out of custody until you're done.
And then if I don't testify, I have to stay until when?
Until the trial is over, until all the defendants have been, I've got these 6 that we have here now, and there's another 6.
No, there's another 12.
There's another 12 or thereabouts that are still outstanding in various forms or another.
Can I speak with her for a second?
Yeah, sure.
My question is, I can ask you a question?
Yes.
So my question is, so what I was just asking her was, if you ask me a question and you feel and I was lying about it, will you lock me back up? No. If you were saying, you say, I didn't talk to Demekion, well, no, I can't talk about that because the judge is in here. You are asking, for example, if you said before that the sky was blue and I asked you on the stand what color the sky is and you said, I said the sky was red, I'm going to say no back before you asked me it was blue. Is that what you were trying to ask me? So explain the independent evidence. If he says he did something and you know he's not telling the truth, what happens? If he said he did something and he did not do that thing, if you believe he did not, so if you believe that he's lying about that, then no. If he admits to doing something on the stand, and he did not do that thing, I'm gonna say, if this is the first time you are saying that, if you have independent evidence to prove it wasn't him, then what? Then nothing. What do you mean? So then he will be fine? Yes, bud. So you're okay with him if he got on the stand and said things that weren't true? Oh, shout out to Kayla. That was good. That was good, Kayla. That was really good. No, I want him to tell the truth. What have I always said to you? I want you to tell the truth. I don't know what's going to come out of your mouth. I expect you to tell the truth. If you say something that is inconsistent with what you said before, then I'm going to ask about the inconsistencies, but I expect you to tell the truth. What you go on the stand and do, I don't know. I don't know what you are going to do. I want you to tell the truth, but I will deal with you, not you saying something different in the matter of that I normally do. If I'm saying something different, right? So when the police question me, they don't question me every time they lock me up. I don't know how many times that was. I done told them whatever different story I could think of to try to finesse my way out of the situation. I don't recall what I done told them. Okay, you can say I don't recall. That is how that works. I don't recall. And he can say that to every single question? I would hope that that is not the truth, because I think there are some things that you do recall and some things you don't. But the things you don't recall, you don't recall. And then I will go through my process of what I do. You can talk to him about what impeachment is. That won't get you locked up. Impeachment will not get you locked up. You can talk to him about what impeachment is. If he says, I don't recall, what will get me locked up? What did I tell you? I don't know. What you did on Friday. So the only thing that gets me locked up is pleading the fifth. Yes. The court instructs you, you need to answer the question. You say, again, I plead the fifth. Again, that's what's going to get you locked up. But if you answer the question, that will not get you locked up. So if you don't want me in jail, why just don't you let me go after the trial over with? You're in jail because you are not answering the questions.
Because you have been given immunity. You
because
are
you
only
have been
in jail
given immunity.
because you got up here.
Well, what about this? I answer the questions. You take away the immunity. I answer the questions and I plead the fifth. No, to questions I feel incriminate me. But then I won't plead the fifth to things that don't incriminate me.
The state can still give you immunity. They can give immunity to whoever they want, okay? And they can make that choice. I don't even make that choice. So if they, like I said earlier, they want your testimony, they figure it's that the jury needs to hear it. What do you have to say, good, bad, or indifferent? And what Miss Hilton is telling you is just to tell the truth as you know it, and let her worry about, even though that you may have said different versions of whatever, that's for impeachment. That's not going to get you in trouble. What will get you in trouble is you just invoking your Fifth Amendment privilege, because you have been given immunity, or as Miss Love said to you this morning, remember, Miss Love said, if you overtly lie about something, like if you tell a bold-faced whopper, then they can indict you on that particular charge. The particular false statement.
That's what they're going to do. That is what I was saying. You will be right back. But if you say something that you know you did not do, like you admit to something you know you did not do, whether you, like murder don't have, no statute of limitations, right? But if you didn't do it, I can't charge you with something you didn't do because I don't have any other evidence but you saying it. But y'all don't you can charge him with false statements and he will be back in jail. That is what I'm trying to say. But if I know that you are lying about that, I don't intend to do that. But if I know right now he's lying, I know he's lying, I'm not going to charge you because I don't know your reason for doing that. But I'm not going to charge you when I know you didn't do what you were trying to say you did now. And that can be a part of this. I know you didn't do it. But it's up to the judge to do that. No, it's up to the state to bring charges.
I don't have anything to do with that.
He has nothing to do with bringing charges. That's up to the state of Georgia. Can I talk to my family and I will make my decision right after I hang up the phone. He's saying he hasn't been able to speak to anybody. His sister just called us. Y'all done me wrong. Y'all just hold me in jail. Don't let me get no PIN number, no nothing. We have no knowledge. We did not know that he hasn't been able to do anything, speak to anyone. The jail system down, but y'all still putting people in it. That part, I don't know. I don't know. We have been in communication with your sister. Your sister actually texted Miss Lenskoy to make sure you were okay. We told her we physically have laid eyes on you. I'll leave that up to the sheriffs. I don't know. So what you think she's saying? Can't tell you right now. I'm talking about that locking me back up. We would have to bring charges. There would be no incentive. Y'all will. We've already had this discussion. Look at what you did to me. You waited until Friday and did this. I done told you every day before Friday came that I was pleading the fifth. No, you did not. As a matter of fact, our last...
Mr. Copeland, let's see if we can get beyond this. Okay, beyond what your concern is, you could have invoked the Fifth Amendment privilege. The state could have turned and said, stop. Had me go ahead and file that motion and giving you immunity. It was going to, they make that decision. They decided to make it on Friday. So even if you would have been more comfortable testifying and invoking your Fifth Amendment privilege, they could decide you as a witness, they want your testimony more than they do you invoking your Fifth Amendment privilege. So they gave you immunity. They gave you immunity, so you've got to testify. Truthfully, as to what you know, truthfully, as to what your knowledge of the particular incident is. So they could have done that anyway. Even if they put you on the stand, they could have said stop. They could have said stop and gone ahead and given you immunity. They could have done that.
So can I get it in some type of writing that if I was to testify, that if she feels as if I lied about anything, they won't lock me back up?
Let me have that, Miss Bumpus. Mr. Copeland, on page 2 of the order pursuant to OCGA 245507, however, no testimony given by Lil Woody as required under this order or any information directly or indirectly derived from this testimony of Lil Woody given by Lil Woody as required under this order shall be used against said Lil Woody and in any proceeding or prosecution for this crime or offense concerning which he testifies under this order. Okay? So you testify about some aggravated assault or murder, they can't prosecute you on it because that is what it says in the order. Okay? The only thing that will get you in trouble is this next little paragraph. Lil Woody shall be subject to the prosecution or to penalty of forfeiture for any perjury, false swearing, or contempt committed in testifying or failing to testify in accordance with this order. However, it is ordered that Lil Woody shall not be required to produce evidence that can be used in any other court in this state, the United States, or any other state. So basically, if you commit perjury, false swearing, or contempt committed in testifying, that means if you just invoke your Fifth Amendment privilege or failing to testify, you say, I'm not going to testify. All right? So the only two real things that can kind of get you in trouble are perjury and false swearing, as long as you tell the truth. Now, As Ms. Hilton and Ms. Bumpus said earlier, you may have told or been asked about situations over and over again that may have changed. What the state is asking you to do is tell the version that really is the truth. If they want to impeach you, they can do that. Or if the other side wants to impeach you, they can do that. You won't get in trouble for that.
You said I will.
You will not. You will not. Impeachment is not perjury or false swearing, okay?
But she said I could purge myself, though.
Now I see you running, coming for my come up. Broke out all your shackles, turned it to some armor. Used to be the judge, but now you have no honor. To die with your pride is to live with all your karma. Now you wanna stay. Now you wanna stay. So now I'm stay.
I did these crimes. I'm telling you that.
Hey, it's your boy, the lead attorney.
I did these crimes.
Right?
Shout out to that cartoon.
Oh no, the video, guys. Somebody made a video and used AV's voice. It was hilarious. Reading the transcript with AI. I was like, it's your boy. AI is racist. It's your boy. Got real urban on me. All right, and so whoever did that video with AV, I don't know if somebody could drop the link. It was hilarious.
Hey, Flesh of the Gods. So shout out to Flesh of the Gods too, who has been like really like, I don't know, not daily coverage, but almost daily coverage content about this case, looking back at different parts of testimony and in-court moments that relate to the things that we're arguing about today. Flesh of the Gods has a great archive of content on the YSL trial, so make sure you check out that channel as well.
But she said I can purge myself, though. No. We're saying two different things. Sorry. Perjury is if you get on the stand and you just say a bold-faced lie, just something that is just wrong. Say you say, I did something, and all the other times you said, I have not done it. And really, while it's perjury, it's really just an inconsistent statement. Oh, my God. Like if you get on the stand and say, I did X, but in 2015 you said, I never did X, then that is what I'm going to impeach. I'm going to impeach you on everything you said in 2015. Meaning I'm going to say, okay, today you said I did X, but in 2015...
We have a security issue. We need to stop for a minute. If we can stop for a minute, please.
I don't know what was told to you on Friday. I have no reason to want you in prison. You have spent enough time in prison for YSL, period. So why would I want that for you? It doesn't make no sense. I said it to you before, and I will say it to you again in front of all these people. It makes no sense. You just said I'm going to have to stay in jail until the last if you don't testify. Get this part through your head. If you don't testify, that is the only thing that is holding you. That is literally the only thing holding you right now is the fact that you keep saying, I'm not going to testify. Well, you haven't said it today. I'm not testifying. I plead the fifth. If you get up there and I want you to tell the truth, like I said before, if you don't recall certain things, you can say you don't recall. That's fine. I want you to tell the truth. I don't expect you to remember every single detail from 2015. I just don't. No one here does. But what I do expect for you is to answer questions so we can get through this. So you can go home, be with your baby for her birthday, see those dogs deliver their babies, go talk to your nephews, and do all these other things. How do you know about my dogs? Because you told me. Okay, what's wrong? I'm stressing at another level, like, I'm just saying, I'm weak. Man, I'm not playing. I'm dead serious, man. Like, this is what our position is. We do not want him in custody. We want him to tell the truth. We want him to testify. That's what will get him out of jail. And, you have to make, if he decides in 2 weeks he wants to testify, then what? And if he wants to stay in jail for 2 weeks, then I don't know why you would want to stay in jail for 2 weeks. I have no idea. He just feels like he's under a lot of pressure right now. Even at the jail, they are just, you can't give me a house arrest. No, you can go home by taking the stand and testifying. That's what you...
And come back tomorrow morning.
We keep on saying yet, but there's no crime. We keep on saying yet, I don't know who's really telling you about a crime. There is no crime. You have done nothing wrong except for, so why am I in jail then? Because you aren't testifying. But that ain't nothing wrong. It's not a crime. It's not a crime that you're in civil contempt.
Two things. Because you invoked your privilege after you've been given immunity, that is why you're in custody, because you get out by testifying. So you testify, you get out. And that's why I was going to bring you why I brought you here early today to just inquire about that. You can remain and hold your position of invoking the fifth or not testifying, but you go back to prison. You go back to jail because that.
You can't sentence me? There's no sentence.
There is no sentence. The contempt is compliance. They want your testimony. That is all they want, whatever that may be.
I don't know what it is, Your Honor. You're in jail for failing to testify.
Failing to testify.
Not for nothing else. There is no crime. You ain't done nothing wrong. I don't know if people are telling you what we are going to charge you with. Nothing. We are not charging you. The state charges you. There is nothing we are charging you with. You're only in custody because you have decided not to testify. That's it. Once you decide to testify.
You remember that word you were talking about? Purge? Okay, you can purge right now. Purge. And get yourself out of jail just by testifying.
I can purge and get out of jail?
Yes, just by testifying.
Not perjury.
Purge, meaning you can get out of jail. You can get out of jail, out of custody, just by testifying.
And what about the other one, the other word, perjury?
That's different.
That's different.
That's a different word, okay?
That can get me back in jail? Yes.
Well, perjury is,
It's not what you are saying it's not what you were saying is not perjury. What you are saying is what we call a prior inconsistent statement. Your example that you gave me, what if I said I did something and I know you didn't do it and you said before you didn't do it? That's not perjury. That's a prior inconsistent statement. You've got to make a decision. So if he starts testifying today, he's going to go home today? He should, so long as he remains. But if you get up there and be like, if you get up there testifying and then we get into it and you start saying I plead the fifth, we're going to be back here again. But if he says he don't recall to everything, he'll be okay. I'm not advising that. But so long as he answers the questions, that's fine. So long as I did these crimes, I'm telling you that. Okay. I don't know what you were talking about, but I think you are saying you want to get up there on the stand and say something. Did we find out if he could talk to his family? No? I mean, if it's okay, we got the sister's phone number. As my attorney, you gotta if y'all want to talk, let me go somewhere. I can't hear you. The judge is over there, so just speak low so he doesn't hear you.
Hold on. Okay, all right. Mr. Copeland, have you had an opportunity to talk with Ms. Bumpus, your lawyer, and Ms. Hilton, the state's counsel? Have you got any other questions?
No, Your Honor.
Is it your desire to give testimony today?
Yes, sir.
Okay. All right, then. Do you all have some clothes for him?
I don't know. Let me go take a look. What size are you? I can't hear you. And what size are you? Little. You had a jacket for him? Oh, but he can't wear a large?
What is your waist size? 34?
32.
Chest. What are you, 34? 34, 36 chest?
Probably 36. Not in my chest. What you mean?
Size. They are going to try to get you some clothes so you don't have to testify wearing that jail uniform, okay?
Y'all don't want to show the people how y'all did me?
Look,
If we can't find clothes, then you may have until tomorrow. I prefer to go in like this. Nah, don't hide it. Can you make him put on clothes? No. I want to go in there like this. Fine, with me.
all right, okay.
Y'all aren't going to try and lock me back up for this? So long as you testify, we will get an order to get you released today.
Whose copy is this?
You've got to make sure you come back now. I want to be real clear. When have I ever ran? You have not. That's the only thing. You have not.
Whose copy is this?
That was ours. Do you want a copy? You can take it, though. It's okay. You still have yours, or you threw it away? I'm going to give him both of these things so he can have some information. Okay.
Are we done?
Yes, I believe so.
Okay, we're good. See everybody downstairs in about 10 minutes.
He's a rat. But goddamn it, he's an entertaining rat. He got Master Splinter beat, and what he's doing is throwing the DA off their mojo.
Well, yeah, I guess there was a secret meeting that happened.
That's gonna be a mistrial.
Between Woody and the judge and the prosecutors.
If that happened, everything that judge has touched is going to be scrutinized now, right? They'll go mistrial before they let that thing go all the way. Convict Doug and give him that door of appeal.
Yeah.
But when they mistrial, it's a good and bad thing because it's good because, okay, Thug didn't find you guilty, but it's bad because now we're going to be dealing with this till 2026. And Thug's attorney, now, listen, say what you want. Dude was gangster with that situation.
Oh, yeah, he said that he wants to do his jail time with Thug in a cell to go over the case. Oh, yeah, he has a long
He said, I'll do the time as long as you put me in there with my client. Everybody gonna hire him.
Oh, yeah, no, he's got $1 million offers, I'm sure, already.
Yeah.
You know what I mean?
I'm so high right now, y'all. I'm about to go to sleep on y'all now.
objection.
Yes, Your Honor. It's
Basis.
the hearsay not consistent.
I sustain the objection.
Investigator Gaither.
Yes, sir.
On December 28, 2023, did you write, "Good morning, Mr. Steele. I have decided not answer any questions at this time. Hopefully you are able to find answers to any questions you may have in my corresponding police reports." Is that what you said? Is that what you emailed?
That is what I emailed after Mr. Steele was given an opportunity to call me and meet with me, and he did not meet that time. So therefore, I was not going to keep rearranging my schedule because he did not meet that time.
Hopefully you are able to find answers to any questions you may have in my corresponding police reports. Investigator Gaither, where are your police reports?
Objection, Your Honor. Asked and answered.
I sustain the objection.
I have no further questions. Thank you.
Basically, y'all keep asking me, do I recall this and recall that, remember this from 2013? I don't remember that from 2013. I keep telling y'all that. That has been my statement since I got here. Your Honor, I've been telling y'all, people constantly hit me with this, keep constantly asking me this and that and third about what's going on in 2013 or whatever. I don't remember. I don't know nothing about 2013. All I can tell you is, y'all got my name on a recorder, my phone number on a recorder. These people threatening me. They calling my phone. Your Honor, I almost lost my job. I got a lot going on behind this hill. I put all this behind me, sir. Everything that had going on with me, I put everything behind me and kept moving on about my life, sir. Your Honor, I can't continue to keep going on like this. I don't remember nothing from 2013, sir.
Mr. Bean, you have to answer the questions, okay?
I constantly keep telling them and constantly keep telling y'all I don't remember nothing from 2013.
I'm going to ask you because I have to lay a foundation. Do you remember telling Detective Quinn on September 17, 2013, on recording, that you add a little more hype when you speak with your wife and them from the jail, that you lied to them?
I remember y'all trying to assassinate me right now in 2024. That's what I remember. That's what I remember. All this going on right here on this, got me up on this stand, talking about this and that third, all this extra stuff that's going on. Your Honor, am I on trial, Your Honor?
Sir, you just have to answer the questions, unfortunately, at this point in time, okay? That's all I can tell you.
Am I on trial?
No, sir, you're not on trial. But you have been properly summoned here as a witness, and you're subject to examination until I release you.
I never consent to do none of this, sir. I ain't signed nothing. My name ain't on nothing. They come get me. Y'all don't threaten to lock me up. Hey, I got a family too. I mean, come on, y'all. I done told y'all I don't remember nothing from 2013. Come with these conversations. Hey, remember we was in front of the house? Conversation we had in front of the house before we went to the Kroger? Keep it 100, man. With yourself.
I can't hear you, Mr. Bean. Can you take your mask off if you wouldn't mind?
Keep it 100 with yourself, not me. We had a conversation in front of the house.
Yeah.
Before we went to the Kroger.
Yeah. You asked to go to the Kroger.
I never agreed to do none of this from the beginning. Before we even had this, what you just played.
Mr. Bean.
I keep telling y'all I remember that for 2013. I didn't really remember that then.
Mr. Bean, who threatened to lock you up?
Sir, I talked to Your Honor. Your Honor, tell you something.
Sir, answer.
Am I on trial for anything? Can I be excused, Your Honor, for anything? Something? Because I really don't understand what's going on. I don't remember. My head hurt. They keep asking me questions about this. Keep asking me questions about that. About 2013, I don't remember.
No, you can't be excused at this point in time, Mr. Bean. You're subject to examination.
I don't remember.
Who you just told the jury, the Honorable Judge Glanville, and all of us, that you've been threatened to be locked up.
I didn't consent to come get on this stand to be a witness, first of all.
Who threatened you to lock you? Lock you up means go to jail.
There wasn't no threat. The subpoena go out. They say you don't show up, they're going to lock you up, you go to jail or whatever, and all this little extra stuff like that right there. I ain't here to point fingers at nobody, say nothing like that. That ain't my job.
You just said
it ain't for me to mention what nobody got going on in their life. I got my own problem.
Who threatened you? You just told the jury that you've been threatened.
I done had all kind of threats, man. Y'all just explored my whole phone number on to the world. People calling my phone right now threatening me, texting my phone. I ain't had no sleep. I've been up all night since yesterday, 7 o'clock, from 7 o'clock yesterday to 6 o'clock this morning. Still getting calls. Still getting texts. That's my personal line y'all just gave out. On live to the public, to the whole wide world.
Who threatened to put you in jail, Mr.
He's answered that question already, Mr. Steele. Let's move on from that.
Do you remember telling Detective Quinn on September 17, 2023, when speaking on a jail-recorded lines, I'm visualizing the story, trying to make it all one. You know what I'm saying? I ain't telling them a lot. A little shenanigan, be bold blank. Remember saying that?
Ms. Love already asked me 1,001 questions. I told her I don't recall nothing from 2013. I don't even recall the conversation really that me and you even had. If somebody else push up on me, ask me questions, let somebody else come to. I give them a story too. Everybody don't keep asking me questions. I'm gonna move on with my life, man. I ain't got time for these games. Y'all done assassinated me, man. Hey, it's about time for some actions now.
One parcel of it is that's why I'm making my ruling in this particular case. Remember, bias. I've got to do something extrajudicial, and you're in your particular. Like I would have to say something about you or your clients or anything like that, which I would never do because I'm a steward of this particular process. So I understand what your objection is, or what your statement is in terms of your motion to recuse, and I'm going to deny it.
And I believe, Your Honor, that under Rule 25.3, that you have to cease acting right now.
No, I don't.
And that you can, if I can just finish, and then I promise, if I can just finish this. I believe you have to cease acting. I believe that under 25.3, you have to look at the timeliness of the motion, and you have to look at the sufficiency of the affidavit. I do not believe that you are permitted to just simply deny without taking those steps.
Is that it?
Yes, it is, Your Honor.
Okay. All right. So noted.
Are you denying at this point?
I'm still denying your motion, okay?
Would you grant a certificate of immediate review?
No, sir.
Because
no, sir.
Grant that certificate. You were always talking about how the appellate court.
No, because if I grant the certificate, it stops the case. Okay?
I don't agree.
And I'm not going to do that.
I don't believe it stops the case.
I'm not going to do that.
And if
you can appeal it at the end of the case. If I'm wrong, I'm wrong. Hey, I'll live by it.
But are you interested in removing the cloud that's hanging over the case right now, Your Honor?
Sir, I'd be real careful about what you're pleading at this point in time and what you're stating to the court. As a matter of professional responsibility, remember, we haven't nugged out all of the issues involved in that affidavit. And I would be very careful if I were you, because you have some professional responsibility obligations individually and to this court. And so, I would just leave it at that respectfully. I don't want to get into an argument with you about that, but I would just tell you that tread lightly, okay, in terms of that at this point.
I understand, Your Honor, and I believe that the certificate of immediate review would be in the interest of the court.
I'm not going to do that. I'm not
going to make factual findings regarding.
I am not at this point in time going to I've denied the motion, okay?
I believe that's an error, Your Honor.
All right. Okay. Thank you, sir.
Thank you.
All right.
Last minute.
I'm not waiting to the last minute, Your Honor. I am not anticipating that we're about to discuss a slideshow.
Focus. We ain't got to that yet.
All right.
Focus. I'm focusing on your behavior at this point in time. I'm not saying to you that the information is not any less invalid, but it's the timing that's a problem. It's a problem, and since you
I wouldn't think that we would be admitting these things, but since I've seen these things, these statements, these out-of-court statements being admitted, I've taken it upon myself. A couple weeks ago, you said to us, please flag things in advance. I took
this
that
is
to
not
heart.
in advance. This is not in advance. This is like we got a jury sitting here. You all didn't get here at 1 o'clock. I told you to be here at 12:30.
I've been here.
I know that you were here early, and I know why you were here early.
Okay.
So, but focus. The focus is on why didn't we file this stuff months ago, and let's wind it out and air it out at that point in time. Okay. So I'm going to ask the state their issue on this. Are you cutting this out? Did you have discussions with Mr. Sharp? Madam?
We did have discussions.
When?
Well, this morning. When you
That's too late. The evidence is excluded. The evidence is excluded. I'm going to exclude because I told you that this was going to happen. No. We're excluding that. And I'm going to exclude the PowerPoint that you all submit. Well, you're not going to wholesale introduce it.
We had no intention, Your Honor.
All right.
Let me just be real clear. We did not intend to introduce that PowerPoint today. I have personally reached out via telephone and called at least 2 members of the defense team and asked them to call me back. And I would like
But you all should not be identifying this stuff the moment of trial while the jury's sitting in a box. And this is the last. I am not gonna tolerate this any further. If you don't get together with your colleagues and flag issues and resolve them promptly, and if I have to take them up, remember, I can exclude them, we'll work the weekends, or we'll do a combination of both. So this time, I'm gonna exclude those 2 sections.
Your Honor, Mr. Atkins, he confronted this witness with those sections. I last week let them know that we were introducing that.
If the exhibit's not ready and you haven't made, no, well, Mr. Shart's got objections to it.
But Judge, Mr. Sharp can get in and have our evidence excluded every day that he makes an objection at midnight, and then comes in and says.
Well, then you all should have gotten your stuff together before then. Some of our juries, please. Some of our juries. Have a seat, madam. Have a seat. You better exclude that, and next time, make sure you're prepared. Make sure you're prepared next time. I'm not going to do this anymore. I'm just not. We are starting right now. It's 1:20. So
Talk to them. We have said we don't agree.
then file a motion and get it before me, and we'll take it up. Both of you all have equally responsibility to do that.
The information they are seeking.
Oh, it's going to be inadmissible right now.
I'm saying, Judge, that you said to file a motion. There's nothing.
I'm not gonna have any more discussion about this, madam. I'm not.
Talked to them this morning
I don't.
about that.
Well, you know what?
And I attempted to try to talk to them earlier this week.
Well, then that's why we have to.
Your Honor, so the court punishes the state because the defense.
I'm not punishing anybody, but but prior preparation prevents poor performance.
Be prepared, Judge. That's why I sent them what I sent them last week. A whole week and a half ago, 2 weeks, Your Honor.
I'm not, well.
And I have asked, I have said I would like to discuss.
Our jury's coming in, madam. Our jury's coming in. Have a seat.
Now listen here, you little bitch.
What you mean?
I'm gonna ask you some real simple questions. I want some real simple answers. You understand? Now let's get this right. Did you have a silver Infiniti?
No.
Did you rent or crash a silver or gray Infiniti?
No.
So you brought Threat the car at 8:15?
I don't remember no. I don't know.
So you brought Threat the car at 8:15?
I guess.
Do you know Mr. Garlington?
Street name.
Do you know Little D?
For sure.
How do you know Little D?
I didn't birth him.
You said you damn near birthed him?
I almost birthed him.
So you was like a mama to him?
Yeah. That mean he my son.
Why you so jumpy?
Bullets hit my car.
Did you tell Detective Alligator you had the car?
I told you. I don't recall nothing I said to no police. You keep sitting right here asking me the same question over and over and over and over and over. I'm tired of it. I'm drained.
Did you tell Detective Alligator you had the car?
Threat was mad. He just like, you fucking keep Excuse my language. He was talking, playing like we somebody to play with, and I was ready. I had them choppers on deck.
Did you tell Detective Alligator you had the car?
I know I ain't complete school, but I think I'm speaking proper English.
Did you tell
You
Detective?
asked me, I said yes, yes. When I say yes, you ask me the same question over and over and over and over and over.
So you brought Threat the car at 8:15?
Me and Threat shot up Rich on McCoy there at the barbershop on Bankhead. I don't know what happened with Threat and Rich on McCoy, but I'm gonna ride with my brother. And they was beefing. And yeah, we put up and did that.
At 8:15?
I don't know when. I know we went up there and shot it up.
So you and Threat shot up the barbershop?
I think I said it loud and clear.
Was Threat with you when you and Lil D crashed the car?
What you mean?
What happened leading up to you and Threat shooting up the
I
barbershop?
told him they go do it.
Why did you shoot up the
'Cause
barbershop?
we didn't know where he was.
So were you trying to shoot Kale?
Nah, we went to send a message.
But you gave Threat the car definitely at 9:45.
I told him they go do it.
Now you see something? Now you see now, you done fucked up. You know that, don't you?
What you mean?
You done fucked up. You know that, don't you, right?
No.
See what I'm saying? I'm saying you know that. You know you done fucked up, don't you?
I don't remember no. I don't remember no. I don't remember. I don't know what. I don't know.
You must refer the motion to another judge to hear the motion, but if any one of the conditions is not met, there is no error in denying the motion. And motions to recuse are viewed and considered by the appellate court for abuse of discretion. Accordingly, the court is going to address each one of the factors as it pertains to both Mr. Steele's motion and, for shortness, Mr. Banks' motion. I find both motions were timely filed. I find that Mr. Steele's motion was in fact filed on this past Monday, which would have been the 17th of June. I find that Mr. Banks' motion on behalf of Ms. Bumpus was timely filed, as it was filed on the filed on the 14th of June at 10:40 p.m. Secondly, I find that in addressing the legal sufficiency of the affidavit, that means, was it sworn? Was it sworn before a notary? Is in proper form? I find Mr. Williams and Ms. Bumpus's motions to be, I should say, affidavits to be in proper form. The third thing that the court has to review, and like I said, I reviewed, is the legal sufficiency of your grounds of the motion. And here's where the court finds that upon a review of Mr. Steele's motion and affidavit, as well as Mr. Banks' motion and affidavit, that both contain assertions bare assertions and legal conclusions which aren't sufficient for the court to grant your motion at this point in time and refer it to another judge for it to be heard. So I'm going to deny the motion at this point in time. I invite you all to look at Baptiste versus the state. Just because adverse rulings have been made doesn't mean that the court stops the trial. So I'm going to make that. I'll reduce both of the motions to recuse to an order, and I will
I will file that so you can take whatever steps you need to necessarily after that. But I don't get into anything about the affidavit itself, argument on that. I just have to read it. Those are the only three things I do. And then if I find it to be not sufficient on its face, I go for it. I just make the ruling at that point in time, let you all take it up. No, I won't grant a motion for a certificate for immediate review. And that's where we are at this point in time.
Hopefully you are able to find answers to any questions you may have in my corresponding police reports. Mr. Gaither, where are your police reports?
And
how you're
Hey, excuse me, Hilton. They told me to let you know they're ready to get started.
Okay, just a minute. I'm just putting my face on.
Welcome, Chief, Deputy, Assistant, District, Special Ops, Attorney, Fumble Lips, Slip-On Hilton. And welcome, Chief, Double Deputy, Assistant, District, Special Ops, Attorney, Lion-Ass Lawyer, in a Dreamland, No Love. I'm Phony. This is Fonny, Fanai, Fanye, Fawny, and Phoebe. We're the fanny pack. Welcome, ladies, to the fine art of Brady. Suppression. Today, we're gonna learn how to keep those pesky defense attorneys in the dark.
We're ready.
Now, Attorney No Love and Attorney Slip-On Hilton, let's start with the basics. What is Brady evidence?
In 1963, the Supreme Court of the United States heard the case of Brady v. Maryland, which dealt with the issue of prosecutors withholding evidence that could potentially exonerate a defendant or lessen their punishment. The defendant's lawyer requested access to the accomplice's statements, but a crucial statement was withheld by the prosecution until after the trial and sentencing had concluded. The central issue was whether this restriction violated the defendant's constitutional rights. The Supreme Court, in its decision, upheld the Maryland Court of Appeals ruling that the suppressed confession would not have reduced the defendant's offense below first-degree murder. The court determined that denying a retrial for guilt did not violate equal protection and maintained that the petitioner should receive a new trial concerning punishment only, not guilt.
What is Brady evidence?
Evidence favorable to the defendant that the prosecution must disclose.
Excellent. Now, how do we prevent that evidence from ever seeing the light of day? First, we misplace it. A little accidental loss never hurt anyone. Or we can bury it deep in the bowels of our file system. And if all else fails, what I had heard was our system got hacked.
But what if the defense requested?
Well, No Love, that's where the delay tactics come in. We stall. We obfuscate. We create roadblocks. By the time they get their hands on it, the trial is over, and they're too tired to fight it.
But what if the defense find it anyway?
That's when we employ the damage control. We spin it, blame it on the defense, or simply deny its significance. Remember, ladies, confidence is key.
Technique 1, the art of misplacement.
Now, let's talk about misplacement. It's an oldie but goodie. You see, evidence has a funny way of wandering off. A misplaced file, a lost hard drive, or even missing police reports. The key is, if you don't write nothing, you don't got nothing. It seems accidental, but the result is golden.
Now remember, Chief Deputy and Chief Double Deputy, the more complex it is, the easier it is to hide a needle in the haystack. What if the defense asks for discovery? Ah, good question. We create a generic log filled with vague entries. The less specific, the better. Is there a risk for getting caught? Well, of course, there's always a risk, but if done right, the chances of getting caught are slim to none. And remember, the ends always justify the means.
Technique 2, the black hole of delay.
Next up, Technique 2, the black hole of delay. This is a delay tactic. This is where patience is your greatest weapon. When the defense requests Brady material, we hit them with a barrage of objections, motions, and appeals. We tie them up in knots until they're begging for mercy. Remember, if you give it to them before the trial is over or before the judge rules, then it's not Brady anymore. Then by the time they finally get their hands on the evidence, it's too late. The trial is over. Or they're so exhausted, they don't even have the energy to fight it. It's beautiful. How do we avoid accusations of prosecutorial misconduct? The key is plausible deniability. Blame it on overworked staff or on a clerical error. Never, ever admit to any intentional delay. Now, what if a judge get impatient? A little flattery goes a long way. Remind the judge of their busy schedule and how your delay is actually saving them time in the long run.
Technique 3, the spin doctor.
The next technique, number 3, is the spin doctor. Now let's talk damage control. If, by some miracle, the defense actually gets their hands on the evidence, we can go on the offense. We spin the story, blame junior staff, or claim the evidence is irrelevant. And don't worry, the judge will usually jump in here. Remember, confidence is key. If you act like you're in control, people will believe you. Excuse me, what if the evidence is too damning to spin? Well, in that case, we resort to plan B. Discredit the witness, attack their credibility, and hope the jury doubts their testimony. Isn't this unethical? Ethics are for amateurs, ladies. This is about winning.
Technique 4, the nuclear explosion.
And finally, Technique 4, the nuclear explosion. Now, if all else fails and the defense is relentless, we have one final weapon, the nuclear option. We lock up the defense attorney, a little contempt charge here, a sneaky remark there, and boom, they're behind bars. The message is clear. Mess with us, you pay the price. Isn't that a bit extreme? Well, sometimes desperate times call for desperate measures. Besides, it sends a powerful message to the other defense attorneys. What if the judge doesn't cooperate? Don't worry about the judge. If he slips up, I'll remove his ass faster than I put him in that seat. A little persuasion might be necessary. A friendly reminder of their career aspirations could work wonders. Don't worry, I'll handle that part. And there you have it, ladies. The complete Brady suppression playbook. Master these techniques and you'll be unstoppable. And remember now, the justice system is ours to shape.
We're here to celebrate.
Welcome to Flesh of the God. Well,
Have you ever had a dream that you want him to do you so much you could do anything?
Hey everyone, welcome to the AI Awards, the only show that's all about the most memorable moments in the legal world.
And tonight, we're kicking things off with a category that celebrates a very special talent. I'm RA.
And I'm Ara, your semi-corporeal guides through this evening's look at the biggest liar in the DA's office.
And tonight, we're kicking things off with a category that celebrates a very special talent. The district attorney's office, who have, shall we say, a creative approach to the truth.
So buckle up, because tonight we're celebrating the most persuasive storytellers in the DA's office.
And he is certainly my friend and one of the people that I respect the most. So if you ask about a personal relationship, I consider myself to have a personal relationship right now, Mr. Wade. I consider myself to have a personal relationship with Anna Cross. I consider myself to have a personal relationship with Mr. Abadi.
Wow, I've been feeling fine, baby.
I consider myself to have a personal relationship with Andrew Evans.
Okay, let me just clarify that.
I have a personal relationship with him as we speak right now. I don't think that's what you're asking. I think that's what you're asking.
When did your romantic relationship with Mr. Wade end? Did it end?
Me and Mr. Wade, we are good friends. My respect for him has grown over these 7 weeks of attacks. We are very good friends. I think, but for these attacks, it would have been a friendship that, as life goes, you would have stopped having. I think that you have cemented that we'll be friends till the day we die.
Let's have it.
She asked about a personal relationship.
She asked when the romantic relationship ended. That's the question.
It's sometime in, I'd say late summer of 2023.
The evidence is going to
The lie detective determined that was a lie.
The evidence is going to show.
All right, folks, let's dive right in.
Now, these aren't just your run-of-the-mill fibbers. These are the champions of alternative facts, the masters of persuasion.
We're talking about the folks who can spin a yarn so convincingly you almost believe it yourself. Almost. First up, we have Felicia Fibberito. Her commitment to the truth is flexible and visually apparent.
Next, we have Chief Double Deputy Assistant Special Ops Secret Agent Lying Lawyer No Love. And finally, we have Fawny Pack. When it comes to gang members, their version of the truth is united.
And the AAI Award for Biggest Liar in the DA's office.
Her testimony is always consistent. Until it isn't. The winner is Felicia Fibberito.
Good morning.
Where are your police reports?
Good afternoon, Mr. Sharp. If you watch the video in its entirety,
I got a white watch. Wanna raid my house so you can steal it?
White, yeah, I guess it's white if you say so, yes. First, I don't know the value of it. Second of all, like I said, there were numerous jewelry boxes. It was, if you watch the video, everybody in there had on body cameras. I always made sure I was on camera at all times. There's cameras throughout the home. So if you watch the video in its entirety, you take it, and the watch is photographed like this, box is closed, it's taken, and the inventorying continues, and then jewelry starts getting packed up.
Not true.
And to the state, no, but I've seen in
Social media?
Twitter coverage of it going missing or whatever you want to. Yeah, I wasn't watching the trial, but my name.
Don't worry about it.
Okay.
Just keep moving.
So, if you watch the video in its entirety, but if you've watched it, like I watched it.
Not true.
So,
Not true.
If you watch the video in its entirety, but if you've watched it, like I watched it, the watch gets
That's
boxed
a lie.
back up. Oh, and you.
That's a lie.
Left there by the team as as an accident. It was left there. I don't know if there's necessarily a procedure on what you take or what you don't. Like I said, there were other things I had asked to be taken, such as photographs and artwork. There was a hostile crowd gathering at the bottom of the driveway, so we were trying to speed it up to get out of there.
You left behind the Richard Mille watch, pink with a white ceramic case.
Again, Mr. Weinstein, as it's being inventoried, the jewelry is being looked at. I use photographed. The jewelry is being put on the thing, if you watch the video, and it's placed on the shelf, and nobody messes with it again.
So is that a yes?
Yes.
Okay, thank you. I have no further questions.
Thank you.
All right. That was the biggest liar in the DA's office. Some truly unforgettable storytelling. We're here to celebrate.
Felicia Fiborito.
Over 1,000. That's the number of open, unresolved, and unprosecuted cases that our current district attorney has. Over 1,000. That's the number of open and unresolved child our current district attorney has in one county alone. 0. That's the number of gang charges that our current district attorney has brought during the entire time as district attorney. I have prosecuted over 1,000 gang charges during my career. I've successfully headed a gang unit. I have won over 1,000 the last murder cases that I've tried. I've won 0 the last child sex cases that I've tried. Our current district attorney.
And that, folks, brings another chaotic convergence of Flesh of the Gods to a close.
Indeed. We hope you've gotten a kick out of this peek behind the curtain. Remember, everyone has their off days, their moments.
If our little show has brought you joy, outrage, or even a mild existential crisis,
then smash that like button. Drop a comment, tell us which meltdown was your favorite. And for the love of everything, subscribe.
Yes, please subscribe. We've got tons more tantalizing tales coming your way. You wouldn't want to mistrust us. It's going to be a whole thing.
And now, for the legally mandated bit. The entities and events depicted in Flesh of the Gods are, shall we say, inspired by stories. These are fictional narratives. Any resemblance to actual people, living or otherwise, is purely coincidental and wildly exaggerated for comedic purposes. We've tweaked and changed things to protect everyone involved. This is all in good fun, a bit of laughter and relief in an increasingly complex world. So please, don't send any angry letters to our headquarters. We're legal. We're just here to entertain, unlike some people we know who are total control freaks.
Exactly. So, until next time, may your drinks be plentiful, your aim be true, and your journeys through life be filled with laughter.
Farewell, everyone. And remember, everyone needs a vacation now and then.
Until then, stay fresh and stay blessed, family.
Hey, Flesh of the Gods. So shout out to Flesh of the Gods too, who has been...
It is time to start protecting Little Georgia families by electing me, Love, as our next district attorney.
No. So I'll look for another email. That's one of the emails I sent maybe 2 days ago. And there's one I sent a while back. You may need to search up email.
When did you send them?
Good night, bears. Good night. Good night. Good night.
RICO is not a crime. It is a category. What is the
category of crimes?
I'm sorry I lied to you, Martin. I just didn't want to go to Arizona.
I'm sorry I lied to you, Martin. I just didn't want.
Violations of the Georgia Code of Judicial Conduct does it take to get a mistrial with...
Mr. Owl.
How many violations of the Georgia Code of Judicial Conduct does it take to get a mistrial with prejudice?
Let's find out. 1, a 2, a 3, a 4, a 5, a 6, a 7, a 9, a 10, 11, a 12, a 13.
Objection. That's intent. I'll overrule the objection.
Could you repeat the question for me?
Mr. Owl, how many violations of the Georgia Code of Judicial Conduct does it take to get a mistrial with prejudice?
Let's find out. 1, 2, 3.
Here's the story of a named Fanny who was bringing up these very crooked lawyers. All of them were full of ish, like their madam. The worst one was love. Here's the story of a man named Brady who was bringing in injustice of his own. They were working all together in a world so cold, till the one day when the lady got promoted and the Grey Goose had Brady kinda drunk. Then this group would somehow form a Rico. That's the way they all became the Brady Bunch. The Brady Bunch. The Brady Bunch. That's the way they became the Brady Bunch. Here's
Well, family. That's it for tonight. I do appreciate y'all coming through. As some of you may know, I have been temporarily demonetized. I would prefer not to get deep into that. That's why I didn't talk a lot tonight. You know, they say if you ain't got nothing good to say, then don't say nothing. So I didn't want to say too much of nothing, because what I wanted to say might have got me in further trouble. So I will hold off on that. But I appreciate y'all being here. Shout out to everybody in the chat. Shout out to Ali. Shout out to I Am Shout. Appreciate you. Shout out to Jersey Girl Trey, aka Trakisha. Appreciate you. Shout out to No One in the Building. Appreciate you. Shout out to Chan, My Black is Golden. Appreciate you. Shout out to Miss D56. Much love. Appreciate you. Shout out to Lord the McDonald's. Appreciate you. Shout out to Aubrey Ya. Appreciate you. Shout out to Lady L. Appreciate you, family. Shout out to Daniel Berry Sports Highlights. Appreciate you. Appreciate all y'all hanging out. Shout out to Kimberly. Hey, shout out to Kimberly hanging out with us. Appreciate all y'all. Trakisha, No One, everybody. Yeah, temporarily demonetized, so if you would like to help, you know, there is still a way to help. All you gotta do is scan one of these 2 QR codes, if I could find them. Here we go. Just scan one of these 2 QR codes and you can help by donating through Cash App or PayPal. Other than that, I appreciate y'all. Appreciate y'all hanging out with your boy tonight. Everything was love. He said, I said, monkey shit. Yep, it's a lot of monkey shit.
Monkey shit.
But I don't really want to talk about it right now because it's going to get my blood pressure up. So other than that, much love, family. Appreciate y'all hanging out. Y'all go check out No One new track. Just dropped. It was supposed to be dropping 10 minutes from now. But it's all good. A little miscommunication. But still go check it out. Appreciate y'all. Y'all stay fresh and stay blessed, family. Have a good motherfucking night. Peace out.
Have a good night. Have a good night. Have a motherfucking good ass night.
We'll be fine.
your money.
All good. Y'all go check that out. We out, family. Peace.
I will be fine. Our kids will not be.
Ain't your money.